It's where I bring in Richard Blok because he's a criminal defense attorney who practices in Idaho. So he knows not only the lay of the legal land, but he also knows that particular jurisdiction. Okay. How unusual was what we saw today, Richard Blok?
Well, I think these jury surveys, when you're talking about the scope of felony cases in general, are extremely unusual. However, when you're talking about these very, very high profile cases, they're pretty common. This is the thing you have to do in order to change venue. You have to get some hard data about what the potential jurors might know and whether they might be biased. So this is a really important thing. And frankly, I think your last guest missed the tone of this and what this kind of stuff is completely. The defense has a brief due on their motion to change venue in about 2 weeks. They need this information. There's a reason they're pissed that they had to stop. There's a very good reason for it. And there's a very good reason they went ahead like this.
Well, in defense of Lauren Mathias, I will say this. The accusation from the prosecutors here is that the social psychologist that they hired, the defense hired to put this survey together and send it out to people in the county, that social psychologist was given information in the non-dissemination order. That's not allowed. If I'm not allowed to get it, neither is the social psychologist. That's my assumption. And then neither are those people, especially if the information is false. So again, as Lauren pointed out, they didn't seem to be so mad that there was a survey going on, because yes, as a defense attorney, you got to do your work, right? They were mad that there was false information, material that was protected by gag, and that the judge had no idea this was going on. Does that not sound legit?
Well, I think the defense may have made a mistake by not letting the judge know what was going on. I'll give you that. However, we don't know what these questions were, and the defense has argued that everything that the psychologist used came from media reports. So if there was some false information, maybe it's false information that existed in media reports, maybe it's false information that are rumors that are going around on Facebook or other social media.
But isn't that irresponsible? I mean, to me, that's super irresponsible, especially if they know the information's false and they're putting it out to the jury pool anyway in a gagged case.
I think it's really important to know if potential jurors believe known false information. I think that's a pretty important bit of information to know, and I think that would help in making a determination whether you're going to change venue. I think that actually sounds very important. Now, that gag order is very broad. They should have been more careful. No doubt about it.
Hey, thank you. You know what, Richard? Thank you, because my next question is to that exactly. This gag order has been so incredibly broad, it's caused more problems than I think the protections that it intended to secure. Instead, there's been all this guessing. There have been family members who've been devastated, and now the defense is so concerned about, you know, the roiling of hands that they need to find out by pressuring or at least pushing into the community, where in every other case we cover, they do that by going on interviews in the press and they talk that way. I'm not saying that either process is perfect, but this one sure is screwed up.
You know, I don't think the defense was trying to put information in the community. They were trying to do a survey that they have to do for this motion, this brief, that they've got to get done because they really need to change venue. I mean, I think we talked about change venue about 1.5 years ago when we started on this case. I think that was one of your first questions to me. It's super important. You got a really tiny community, 40,000 people, all highly connected to that university because it is a university town. Everybody has some connection to that university there. I think it's going to be a really hard community to get a fair trial in with a case that has been this explosive, that has had this much of an effect on the community, just had this much media attention. I think they got to do it. And if they don't get this motion, they should file a second one and a third one and a fourth one until they get it changed.
Yeah, that was my next question. Do they really need to move or at least have other jurors bust in? The one good thing, though, Richard, that came out, well, at least from my perspective, that came out of the hearing today is that we're going to hear a lot more hearings. Apparently now we're going to get like at least one hearing a month on this case, so it won't be so, you know, judicially dark. I've always said we don't operate in gulags in this country. And so now there'll be a little bit more light shed on the process with these once monthly. So can you at least open up a spot on your calendar for us once a month?
I'll see what I can do for you. Thank you, Ashleigh.
Thank you, Richard. I appreciate it. Always love hearing from you. Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.